Good morning, everyone. Thank you for joining us this morning for this webinar on funds transfer fraud. Think it couldn't happen to you. There are a few more people that have joined us now, so I am going to kick off. We may have some more join us as we go. If you have any sound issues at all, please drop me a note in the chat bar at the bottom. We have tested this morning, so we should be fine. I think we're all coming through loud and clear. Usually, if there's any kind of interruption, I would suggest coming out of the webinar and logging back in, depending on where you're remoting in from. There can be some signal issues if you're working remotely on your end. But the other thing to say is that we are recording the webinar, and so Searchers UK will be sending out a copy of the recording to you afterwards, so you can share that with friends and colleagues and listen to again if you need to. So once again, a warm welcome. I'm Emma Badley from Lawyer Checker, better known perhaps as the Practical Vision Network. I'm going to be talking to you this morning about instances of fraud that have occurred in real situations for law firms. And I think there is a tendency for all of us to think that although we know there is a big risk and something is happening on a large scale, it's not going to happen to us. So I'm here this morning to give you some information on where fraud has taken place, how it's occurred, and what you could have done to mitigate that fraud, to prevent that from happening. And hopefully there'll be some key takeaways for you from this morning. So just by way of introduction, I'm going to just give you a bit of background on who we are. I know many of you will have heard and will be using Lawyer Checker as part of your risk management process, which is great. We are in fact Practical Vision Network, and Lawyer Checker is one of our brands. You may also be familiar with us as the publishers of today's Conveyancer and today's Legal Cyber Risk, both of which are free publications that I highly recommend that you sign up for. Just go to the website for each one. They land in your inbox on a weekly basis, and they're a fantastic source of information, both for conveyancing issues and also for cyber risk associated around that. So I recommend that you do sign up for those if you haven't already. Beg your pardon, I've just skipped slightly ahead by a slide. So let's have a look at our first case study. What we're going to do is have a look at some examples that have occurred, and then have a look at some of the background to it and some of the ways which the firm could have avoided what happened. So in this first particular case study, a couple was involved in selling their flat back in February, I believe it was, of last year. Paul and Anne Lupton are the couple in question, and in this particular case, they were selling their flat for £340,000, and Mr. Lupton's solicitor emailed him, as many solicitors do, requesting his bank account details for the sale proceeds to be paid into. And as many of us, I'm sure, would do, and as millions do regularly without thinking, Mr. Lupton replied and sent his Barclays bank account number and sort code back to the solicitor. Now, this email was intercepted by fraudsters. This is something that can very easily be done to email. They can intercept email quite easily. Email is a fairly old system now. It was designed in 1972. We use it in this day and age for purposes that it was never intended for, and it is an open protocol. If you are sending email, as many of us have got caught out doing from your iPhone, from your smart device, even on a computer, sitting in a public Wi-Fi area and using the public Wi-Fi, which is not encrypted end-to-end, doesn't require you to put a password in, then those emails are highly susceptible to something that we call packet sniffing, which is where fraudsters can intercept those emails and look at the content. So in this particular case, the email was intercepted. The fraudster posed as Mr. Lupton. He quickly emailed the solicitor back from the same email account that Mr. Lupton was using, and he told them to disregard the previous details and send the money to a different account instead. Consequently, a few days later, when Mr. Lupton called his solicitor to chase the payment, they discovered that he'd actually been defrauded out of the £340,000 worth of sale funds. Both parties contacted Barclays and the police, and in fact, in this particular case, Barclays was the account provider for all three involved. The solicitors, the fraudsters and the Luptons. Now, the account was frozen and £271,000 was returned to the Luptons, but unfortunately, they were still out of pocket by £62,000. So what are the things that we can take away from this? Well, number one, this is a very common fraud. Misdirection of either mortgage deposit funds or the misdirection of sale proceeds is a very common way that fraudsters will choose to get their hands on money transfers. There's a couple of things here that are standout. I would encourage any consumer to think about the way, any client, and for you to encourage your clients to think about the way that their law firm would send their secure details to them. So in this particular case, the law firm sent an email requesting the bank account number and sort code to the consumer. But law firms would normally, and this is the best practice, send their own bank account details out in a client letter. They would not send it to you by email. So think about the way that they send their own bank details in a secure fashion, and don't go outside of that protocol if you're a consumer and email bank account details to your law firm. They should always be given back to them within a client letter or in some kind of secure mechanism. You never do that on email. That's one of the main things here. And the other thing is that fraudsters will look within emails for buzzwords. So they will look for words like account numbers, sort codes, that kind of thing, and they'll be picking up on the potential within emails to launch onto something like this and potentially intercept it and send a fake email. The other thing that could have been done and should have been done really by the law firm was that they could have used the consumer bank account checker product, which is a very simple risk product that essentially stops exactly this kind of fraud, using Experian's database where they carry something in excess of 85 to 90% of all UK bank account information. It's a cheap risk. It's a cheap search to do. It's £2.50. If your lawyer is not using that, or you as a law firm is not using that, you would be advised to do so in the sense that it will help you comply with the stricter requirements now on money transfers. You can simply check that the consumer bank account number and sort code that you're sending the money to actually belongs to that consumer, and Experian will bring back in that search result an exact match on name, date of birth, address, bank account number, sort code, whether it's a joint or single account. So in this particular case, this fraud could very easily have been avoided, even if the solicitor had gone as far as to request the information by email and had actually received the email back from the fraudster. They then should be checking that account number and sort code against CBAC, Consumer Bank Account Checker, and they would have quickly seen that that was not the bank account that belonged to Mr. Lupton. So that's some of the takeaways from that one there, but again, a very common type of fraud, unfortunately. So let's move on to our second case study, and this is a huge amount of money that was lost in a bogus property transaction to a property developer, Nick Christophe. In this particular case, a couple lost £735,000. And what was going on in this was that the property developer was planning to buy a Tudor-style 4-bedroom house in North London suburb of Hadley Wood. Some of you may know it. It's a very, very nice area indeed. So he appointed a conveyancing solicitor to act on his behalf. The solicitor who was acting on his behalf was put in contact with the seller's lawyers by the estate agent. So the firm took steps to verify that the firm was legitimate by searching for the solicitor, who in this case was called John Dobbs, and the firm, Acorn Solicitors. So again, this was the firm that the estate agent had recommended. And they used the FAS facility on the Law Society's website. Both the name of the solicitor, John Dobbs, and the name of the Acorn Solicitors were listed as genuine. Now, you may have heard about this case study already, because Acorn Solicitors has kind of become a bit of a kind of famous case study within the legal industry, you know, the infamous Acorn Solicitors. But I'm just going to show you how easy it is for a law firm to set themselves up as a fake firm, or fraudster to send themselves up as a fake firm. So this supposed sale went ahead, and money was transferred. The £735,000 was transferred in deposit completion monies to Acorn Solicitors' bank account. And it was only after the property's true owners, Lloyds TSB, started eviction proceedings against Mr. Christophe and his partner that the fraud came to light. So it became apparent quite quickly that John Dobbs is not a real solicitor. Acorn Solicitors don't exist. They're not a genuine firm. But by that time, he had disappeared with the sale proceeds of the house. Nick Christopher had disappeared with the proceeds of the house. The police established that the fraudster had stolen the identity of a retired solicitor with a different name. So he'd applied to the SRA to change the name of the retired solicitor to John Dobbs, and then he'd later applied for approval to practice under the name of Acorn Solicitors. They even had a website that looked genuine. Of course, they wouldn't have had a physical building or presence. Once they were approved by the SRA through these applications, both the names John Dobbs and Acorn Solicitors were listed on the Law Society's FAS service. So quite an infamous case, and actually quite extraordinary that a law firm who don't exist and a solicitor who had been an original solicitor that had retired but that was then having his name taken over and changed could do so easily, and the details end up as looking like a legitimate conveyancer and a legitimate law firm on the Law Society's FAS service. So there are a number of things that we need to look at here. I think the main one here is you cannot in this day and age, unfortunately, trust any lists to give you the security that you require that the firm or the solicitor that you're dealing with are genuine. That's simply not necessarily the case. You have to really be looking at conducting checks when doing your money transfers, checks on the conveyancer on the other side, checks when you're transferring money to that conveyancer that they are who they say they are and that the firm is legitimate. And actually from the 1st of May, many of you will know that both CQS and Lexel, if you are an accredited firm under any of those schemes, do now have some very robust requirements in place that require you to be doing those kind of checks and having a robust process in place for doing those checks. It is not enough to go to a website and check that they are listed there. This clearly demonstrates that it's very easy to set up fake information. Really, you need a dual process in place here, and in fact, a dual process would have taken place had you used account and entity screen search, for example. So that's a search where you can search against the conveyancer's name. You can search their account number and sort code against their name and their address of their law firm to check that, number one, this is a genuine firm, but also to check that they have got the account number and sort code matching to that firm name, that it does belong to them, and that there is a track record of conveyancing going on in that firm by virtue of the fact that they've got a number of searches against their name. So the way that account entity screen search works, or you may know it better colloquially as the lawyer checker search, it's one of the searches, but the lawyer checker search that allows you to search against the conveyancer's name will bring you back information as to whether this is a known firm with a known bank account number and sort code, whether they have a frequent result search against them, whether they have an infrequent result search or an unknown. And both in the conditions of infrequent and unknown, you get this double layer because you get further research that comes back to you. And in the further research report, it will then look at things like the physical presence of a building. So Google Map, as part of that extensive further research that comes back to you in the event of those two different results, infrequent or an unknown, would have shown us that there was no physical building against Acorn Solicitors, that there's not, they don't have a physical address, they weren't a real firm. It would have shown us a number of different things, checked against land registry, transfer of values. It would have checked against Companies House. It would have checked against 5 or 6 other databases, including CQS and Lexel and the SRA, just to give you due diligence information on the legitimacy of this firm. It would have been very easy in this situation to find out that this was not a real firm had some of these steps been taken. So the first thing is, don't assume that what you're reading on a list is accurate. And the second thing is, do put in a process and a procedure which gives you a sort of dual process of checking. Check against the conveyancer, check that on account and entity screen, the bank account number and sort code. That will check how much searching has been done against their name and how much they've been involved in conveyancing. if they don't have a strong track record, a strong history, it will come back as an unknown result or an infrequent result, and then your further research report is triggered, and that will give you all the information you need to make an informed risk-based decision. And remember that the SRA codes of conduct require you to make a risk-based assessment. So the onus is still on the law firm to find out this information. And if you have done enough due diligence and have a process in place which is strong, and you have conducted the right searches, and you have those on file as part of your procedure, then you're in a very strong position to cover yourselves. But the chances are that you'll be in a very good situation if you've done those things anyway, and this kind of thing will be highly unlikely to take place. So a couple of takeaways there for you. I want to move on to case study 3, because in this particular case, we can see that there was a failure of the SRA to recognise an email that was sent. Again, this goes back to the SRA website and their lists, not necessarily assuming that what you're reading is accurate or correct. In this particular example, we've got law firm A who'd been acting for both the purchaser and the lender, who'd agreed a mortgage with a chap called Mr. Kalpesh Patel, and he was buying a property in Sutton Coldfield in West Midlands. Again, nice area if you know Sutton Coldfield. So firm A received a letter from the seller's solicitors, who we'll call law firm B, saying that they were acting for the seller of the property being Shamsun Bijam. The letter came from law firm B's Small Heath branch and was signed by a business owner. Because law firm A had not previously dealt with law firm B or the named number of staff, they checked their existence and their office at Small Heath as recommended by the CML Handbook and the Law Society, and they went to the websites maintained by the Law Society and the Solicitors Regulation Authority. The SRA website confirmed that the owner was a qualified solicitor and a sole practitioner, and it confirmed the existence of the practice with branches in Birmingham and a practice in Small Heath. However, it would appear that actually someone was pretending to be the legitimate owner of law firm B, had notified the SRA that they were going to open a new office in Small Heath. So this fraudster had done their due diligence, had done their research, and they had found out that this particular law firm B actually did have a small branch in Small Heath, and they used that information to notify the SRA that they were going to open a new office in Small Heath. The SRA failed to recognise that the email address used by the fraudster was different to the one that they held on file for law firm B's director, and they just added this new branch to its database. So email modification fraud is huge. There are a number of different levels of sophistication with email modification fraud. In this particular case, what makes this even more painful is that this wasn't even a sophisticated version of email modification fraud. The fraudster hadn't copied the exact email address of this solicitor and this business owner. They had actually sent an email that was similar to it, but not the same. So even more reason, because it was a different email, for the SRA to have picked this up. We all should be taking great care, as I'm sure you are, to look at email addresses that are incoming. Now, we know that 72% of cybercrime currently is conducted by exact email modification fraud. Those are impossible to spot unless you somehow see a difference in tone and language, or you do your checks and call your solicitor, or you call your colleague if you've got an email from a colleague and say, did you just send me this email? That's an exact email address that's being used. They've spoofed the exact domain, posing as the solicitor using their exact email address, and often it's just identical in terms of the way it's mocked up. But in this case, there was a chance that this could have been spotted, and it wasn't. So the SRA failed to recognise the email, which was slightly different from the original email that should have been being used by that business owner. They went ahead and added this branch. Therefore, law firm A believed they were dealing with a legitimate firm because they had checked that this branch was listed, and they had checked that this law firm was listed on these websites maintained by the Law Society and SRA, and they dispatched the funds to purchase the property. There are a number of glaring issues here. The first one, of course, is the use of phishing email. always being aware when dealing with other conveyancers or with consumers to look out for email addresses, to try and spot ones that are slightly different. You won't be able to tell ones that are identical, but there are ways you can protect yourself from that, and I will come on to that slightly later. But in the cases where you can see that it's one letter different, where it's one number different, pay extra careful attention to what emails are coming in and checking the addresses behind them. The other issue here, of course, was law firm A's I suppose the word would be inability to do sufficient checks. And I think, again, with the new CQS and Lexel requirements, with the guidance being given by the SRA, although they themselves have the incorrect information on their websites, giving you guidance on being extremely careful that you have very robust procedures in place to check who you're dealing with. It's not enough to simply assume that because this has been approved by the SRA and is on their website, this is a legitimate branch, a legitimate conveyancer, a legitimate person. So this again goes back to using some kind of electronic checking, using a robust procedure as required by the CQS and Lexel to make sure that you are checking money transfers between conveyancers, and you're checking the legitimacy of who you're dealing with, and that you're putting those checks in place, ideally on a blanket policy basis on every single transaction that you do. Principle 10 of the SRA code says that you need to protect all client monies, not just some. So our best practice model is to strongly advise that you do this in every situation, even if you think you know the firm well. You never know where the loopholes are going to be. You never know what new staff have joined. You don't know where people are going to be compromised. So again, an account and entity screen search in this particular case would have absolutely flagged this up as either an unknown or an infrequent. I would have then gone on to do the further research report, and it would have come back and raised all sorts of alarm bells. And I think it would have been extremely clear that this firm was not a legitimate firm and had actually set themselves up as posing as somebody that had a real small branch. So case study 4 is a really interesting one to look at, because this was actually quite famous at the time. I don't know if anybody remembers this, but it appeared on page 5 of the Times newspaper on the 2nd of May this year. I actually spotted it and was aghast that it had made page 5 of the Times, and I can only think that there was absolutely nothing to say about Brexit at that time, and if only that were the case now. But at the time it made it to page 5 of the Times, and the law firm concerned was Woodford Solicitors. It was all over the Times, so this is public knowledge. And in this particular case, Nicola McConnell, who was an older lady, 70-year-old lady, and her husband were defrauded out of a massive £613,000 of sale funds when they went to sell their 5-bedroom house in Fulham in southwest London. They sold it for £1.9 million, and proceeds coming to them were just over that £500,000 mark. And in this particular case, what makes it even more frustrating and sad for them is that they're extremely cautious people. I think as a lot of that generation are, I know I can speak from experience with people in my parents' generation. Some of them are extremely adverse to using electronic banking methods. They're very worried about security, sending things by email. So this couple had taken great pains, because they felt vulnerable, to putting their bank details through the door on a handwritten note to their solicitors with instructions about where to send the proceeds of the sale. So the fact that they actually got caught out is just terrible luck. And not great serendipity at all. So this particular couple, as I said, they'd never used computer banking. They kept all personal information off the internet, so they provided their bank details through the door by letter. Everything was going quite well with the transaction until the morning the contracts were due to be exchanged in February 2017. And the solicitor in question, Woodford's, received a very poorly written email sent to them from a fraudulent address saying, after due consideration, I want half of the proceeds paid into my account you have on file, and the other half paid directly into my fixed saving accounts details below. Please reply to me now so that I know you have received this instruction. I think it's obvious that huge alarm bells would be going off at this point. Number one, if it was poorly written, I would question that, even if I had not received an email from the client before and they were clients who didn't really like to use email. Something would feel up to me. If you look at the profile of the people concerned, Nicola McConnell, she was 17, her husband, they live in a very well-to-do part of London in Fulham. They're likely to be the sort of people that would be capable of writing a decent email. I think that will be kind of the first alarm bell there. But the second thing would be that this is very late in the day, and this is often a big flag as well, that fraudsters will not go for the whole of the funds, but in order to divert suspicion, they will try and go for half the funds, and that should be a red flag to you as well. This is one of sort of the classic examples of fraudsters actually trying to infiltrate and get their hands on funds, as they will try to only go for part of it to try and avoid suspicion. If anything, I think it actually adds to the suspicion, but that's what they feel in their minds. And also, it's just before exchange, and all of a sudden the couple wants half the funds paid into a different savings account. Not unusual for people to be having a conversation perhaps somewhere in the conveyancing procedure about a different account. That would normally, I would suggest, take place in person. You would certainly expect, if the couple were an in-person couple and had not used email, that they certainly wouldn't be doing it at this stage. They've taken great pains to put the information through the door of the solicitor. Why would they not be doing that on this occasion? So there should be massive red flags going up all over the place. But in this case, the solicitors tried to phone Mrs. McConnell, which is not a bad thing to do. It's one of the good things that you should do in this particular case, to confirm that she did want the proceeds of the house sale to be split this way. And an absolutely bizarre series of events took place. Rather than asking her whether she had sent that email, which would be the first thing to do, they actually found that at the time of the call she was busy packing. She couldn't remember the details of her sort code and account number, but in fact it was a Metro Bank account, and she simply said, yes, I've got a Metro Bank account, which is what I've already given you. And the firm duly transferred over £613,000 to the account. They only recovered £150,000 of this. And in this particular case, Mr. and Mrs. McConnell got the rest paid back by the solicitors. So Woodfords have had to foot the bill for this. They have been in the public media. It's a terrible case for everybody involved, both the couple involved and the solicitor, and their reputation and their branding. The couple involved went through, the newspaper article actually elaborated on the trauma that they went through. So this is devastating in so many ways. Now, they were lucky in that they eventually got all of their money back, but most people don't get all of their money back. As we've seen in previous case studies, we sometimes get some of the money back. Sometimes the bank pays some of the money. Sometimes the law firm has to pay some of the money. Sometimes nobody gets any money. You know, it's a really sticky wicket if you get caught out like this. There are some really easy things that you should be doing and putting in place that would have avoided completely this kind of fraud. So number one, an email comes in from a client, in this case, who doesn't email. You pick up the phone to them, yes, but you don't ask them for their bank account number and sort code. You check whether they've sent the email. But primarily, again, a consumer bank account checker search, which is going to cost you £2.50 as a firm, and which you can pass on to your clients in the same way as you do your account and entity screen search fee. These are all permissible fees. In fact, most firms now are absolutely charging a fee for checking, for security checking. I think clients expect it. I think they want it. I think they would take great comfort in having it in most cases. It's not a big cost to you. You pass it on, but a consumer bank account checker search would have immediately flagged up that this new account number and sort code that was given did not belong to Nicola McConnell and her husband, and that would have been the end of the matter. Experian would have held account details for that account number, and it would not have matched the account number and sort code of Nicola McConnell or her husband. The address wouldn't match, the date of birth wouldn't match. If they got in this particular case and unable to check, remembering that there's about 10 to 15% of account numbers and sort codes in the UK that Experian don't hold data for, then you're not charged for that search, but it would for me, that would ring a flag anyway, and you would go ahead and do further due diligence checks. So if you're unable to check via Experian, via the consumer bank account checker search, which doesn't happen very often, it's extremely rare, then you would take greater steps to check. You would phone the client and you would ask them, it doesn't matter whether she's packing or she's busy, no money gets transferred until you have verified that that's their account. You ask her to confirm her account number and sort code over the phone. Better still to physically bring in a copy of that. At that point, though, she would have said, you know, that's not my account number and sort code. So that was very easy to stop. But I think consumer bank account checker every time is going to put pay to any activity like this at all. The unable to check results that Experian sometimes come out with, and again, it's only in sort of 10–15% of cases, are purely because there are still a number of non-consented accounts in the UK which date back to the 90s and early 2000s, and they are too old to have had terms and conditions agreed to be on the consumer bank account checker database that Experian holds. So slowly Experian are getting around to consenting those accounts in. There's also the very occasional circumstance I've seen where somebody holds a bank account with a bank that's taken over a smaller bank at some point in the past. The smaller bank have never consented terms and conditions for account data to go to Experian. That simply requires the consumer to go to their bank account and say to their bank and say, please can you make sure that you are signed up for the consumer bank account checker, or in fact Experian call it bank account wizard, to make sure that my data is included in it. But you know, sort of 85% of the time, using consumer bank account checker will give you the result that you need, and that would have absolutely prevented this terrible fraud, and the trauma and stress that this couple went through, and also the untold brand damage to Woodfords. Case study 5, we've only got 7 case studies, so I'm coming towards the end of the case studies, and then I'm going to give you a little bit more information around some of the things we've been talking about. So after locating a flat that he liked, in this particular case, the consumer instructed a conveyancing firm by email. A month later in December, he was sent an email from a different address querying whether he had funds available. So whilst this email contained both the name of the solicitor and the firm, it was sent from a Gmail account. However, in light of his experience of other firms who used 2 email addresses, and there are firms that sometimes do that, the consumer didn't question the legitimacy of the email. Seeing the name of the company, he had stated also provided him with reassurance, so he took the value of that email at face value. A few days later, the fraudster, who of course had sent the email, sent a further email requesting that the funds be sent to the vendor's solicitor in order to ensure that the transaction would be complete by the end of January. So again, a case here of misdirection of deposit funds. According to the consumer, the correspondence with the criminal and the genuine firm continued, with, in fact, on one occasion, both addresses even included in the same email. The consumer stated that this was not, however, picked up by the solicitor at the firm. Telling the paper, as this was reported to the news, that he felt pressure to transfer the funds as soon as possible. He borrowed money from his company. He then made a bank transfer to an Ulster bank account of over £500,000, and this was in line with the instructions from the fraudster. He's now nearly £600,000 out of pocket. I hope that everybody listening to this is scratching their heads and thinking, what on earth, how could this not have been picked up? But it just goes to show that in the busyness of the day, when you've got consumers that are used to responding by email, they're used to responding from their smartphones quickly in a Costa coffee shop where the Wi-Fi is open, there's no password protection on it, where a firm is busy, where a conveyancer just wants to get things done, that these things can slip through the net. So, number one glaring problem: who uses a Gmail account for their work purposes? I hope nobody on this call is doing that. Your client should certainly be extremely wary of ever receiving an email from their lawyer, from their solicitor, which comes from a Gmail account. That is not a business address. So again, this goes back to some of your requirements, and the onus is on you guys to be educating your clients about what to look for. And unfortunately, we have to be educators. Lawyer Checker spends a lot of time, I personally spend a lot of time around the South, seeing firms, training and educating them on what to look for, looking at risk, looking at cybercrime, looking at the stats, talking about best practice. I can educate firms, but it's up to the firms to educate their clients. So number one glaring problem here, a Gmail account was involved. Easy to mock up. Extraordinary that this isn't even, as I said earlier, one of the most prolific exact email domain copying email frauds. That's what we're normally seeing. So this was an extremely sort of not only inappropriate, but just an extremely inexperienced, novice is the word I'm looking for, sort of a novice attempt at fraud, but somehow they managed to get away with it. So they didn't spot the Gmail problem. There was also another email that came in requesting funds to be the vendor's solicitor, to be sent to the vendor's solicitor in order to ensure the transaction will be complete by the end of January. The consumer should have phoned his solicitor at that point to check and verify that email, particularly as it had come from a Gmail address. And the fact that at one stage we had both the criminal and the genuine firm using both email addresses in the same email is extraordinary. So again, some issues here with the solicitor as well. Both the, I would suggest that both the consumer and solicitor are massively at fault here for not picking up some of this email content. Looking at what email addresses are being used, making sure that anything that is CC'd is legitimate. Should it have been CC'd? It wouldn't be common practice for a conveyancer to be including anyone else in the email necessarily if they're corresponding directly with their client. But be aware, be looking at what's coming into your email account, be looking at the email addresses used. And then this particular case, again, you know, the consumer felt under a huge amount of pressure. You know, he was under pressure to transfer the funds as soon as possible, and so he made the bank transfer to this fraudulent account number. In this particular case, vendor conveyancing fraud in terms of the misdirection of funds is extremely common. You need to be, as I get again, thinking about how you transfer your own bank account number and sort code details to your clients at the beginning of the process, which should be in a client letter. If you're receiving an email from a consumer that says that they've got this instruction and they're going to be transferring funds, you need to be picking up the phone and making sure you're doing checks on that. Also in this particular case, spotting this fraudulent email address in the communication would have been an absolutely huge giveaway. So there needs to be some very clear sort of study of what was going on in this particular email. It was a very poor level of spoofing that took place. It could have been picked up very easily by the law firm in question. So making sure that you are addressing the information in this, in any email that you see coming through and going back and forth, and making sure that you are liaising directly with your consumer, and that they know that you will always provide bank account number and sort code details for them to transfer money through your client letter. If they're in any doubt of that, to pick up the phone. You can always check their bank account number and sort code, as I said, using Consumer Bank Account Checker. So there are a number of things that you can be doing and should be doing to make sure that these kinds of things don't happen. That was a very unfortunate one because it's very easy to spot a fake email if it's a letter different, a number different, and particularly where there's a Gmail address concerned. The correspondence was going back and forth between the law firm and the consumer. The law firm could have picked that up, phoned the consumer and said, ignore that email address. Do not communicate with that email address. It's clearly not from us. And doing a check on the account number and sort code, making sure that they know what account number and sort code they're supposed to be paying into. So some big lessons in that one as well. I want to talk very quickly about some of the reliance on the APP scam firms and the contingent reimbursement model code for authorised push payment scams. So there is a presumption now that when a customer has been the victim of an APP scam, firms should reimburse the customer. However, there are some exceptions to this, and they include when the customer ignored the effective warnings, where the customer is a micro enterprise of charity, it did not follow its own internal procedures for approval, or where the customer has been grossly negligent, although there is no definition of what that is. Now, that all sounds great, but A customer is actually defined as either a payer or a consumer, as defined by Regulation 2, Clause 1 of the Payment Services Regulations. So that's either the payer or the consumer, could be either. And the payer is a person and the consumer is an individual other than a trade, business or profession. So even if your bank is signed up to the voluntary code for this, you are not protected. So there's often an assumption that this contingent reimbursement model code will offer some kind of protection in these kind of circumstances. But in actual fact, as you can see there, you through these definitions around the payer and the consumer being an individual and the payer being a person, even if your bank is signed up to the voluntary code, you're not going to be protected. So you need to be thinking about the start of the procedure and not the fact that you'll be covered if something goes wrong, because as we've seen in all of these different cases, liability still lies with the law firm. Your Principle 10 instructs that you have to protect all client monies and not just some. So the onus is on you to make sure that you are safely safeguarding transactions with conveyancers, that you are conducting proper checks into who they are, verifying that they are who they say they are and their account number and sort code, but also then making sure that you have a robust procedure in place for checking that you're transferring money to the correct consumer bank account. And again, there is the CBAC check that will do that for you. So just now, phishing and vishing, I think they're really important to just touch on. I think we all know what phishing is. Vishing is the phone call version of phishing. Phishing is still absolutely ripe, and in particular, full email modification fraud as a means of phishing, as I said earlier, is 72% of all cybercrime now. So let's just have a quick look at two case studies of classic examples of phishing and vishing that have taken place in the last couple of years. There are hundreds and hundreds that take place all year, but there's a couple here that may be interesting to look at. So just to get you thinking about some of the scenarios, in this particular case, a large law firm's HR department received an email from a senior executive asking for staff payroll information. It responded with the details of what the executive asked for, which included names and financial information. Now, in this particular case, the CEO, who it was that had their email spoofed, and they had it exactly spoofed, so it was the exact email address, it had gone to the HR department, they acted on it. The CEO had been victim of what is often called CEO whaling, so it's a phishing attempt going after a big fish who we'd often call a whale. So in this particular case, because the information was sent back to the supposed CEO, but it wasn't him that had sent it, so it was sent back to the fraudster, some of the employees of the firm began reporting that they had been victims of identity fraud. So we're not always looking at money here as the gain. Sometimes fraudsters will go for information that will enable them to steal identities. When the firm investigated and learned about the email to the HR department, it hadn't been from the CEO, and it had been a CEO whaling attack or a CEO fraud phishing scam. So one, again, to be aware of internally, if you're someone that receives emails from either a managing partner that's more senior, if you're in the accounting part of your firm, if you're in the HR department of your firm, maybe you're the practice manager, be aware that if you get an email from a senior executive asking you to give information across that is sensitive information, staff information, payroll information, or account details, do check verbally with the person who is supposed to have sent that. They may not have sent it. Vishing is the phone call equivalent of phishing, and in this particular case, this happened to a firm in the north. Actually, this is a real case. They're all real cases, but this is a real case that I'm aware of that I think happened last year. The law firm receives a call purporting to be their bank relationship manager, a call from someone purporting to be their bank relationship manager, and it was the managing partner that received the call, and he was asked to move funds to a different account due to an operational problem with the bank. The fraudster told the managing partner that he had called him directly because he was wary that the contact he had wouldn't be able to authorise to make those payments. And this particular thing is quite common because it plays to managing partners or partners' egos. Forgive me if there's any partners or managing partners on the call who don't have egos, but I think a lot of the time as human beings, we're quite happy when people come to us and say, I don't think so-and-so has the authority for this, but you do. And you think, yeah, I have the authority to do that. So in this this particular case, he gave the information, and the managing partner transferred the money. And it was only when he discussed this with a fellow partner later in the day that suspicion was raised. At that point, the firm contacted the bank and they soon realised they had been victims of a phishing attack. It wasn't a phone call from the bank, and they lost £200,000 of their client monies and no funds were recovered. So just looking at our final case study now, case study 8. This is another whale phishing attempt. A lady called Patricia Riley worked as a credit controller for a media company in Scotland, and she was scammed back in 2015. Excuse me. It started with the fraud started with a whaling phishing attack. Fraudsters claimed to be the managing director of the company, who had ordered £24,800 to be paid by chaps. And that's a payment that will clear on the same day the request is made. And this was a request to be made to one of the company's clients. Before the initial payment was made to the fraudsters, Patricia excuse me, consulted her line manager, who then issued the payment to be made from the firm's bank account. Whilst the managing director, Yvonne Bremner, and Riley's line manager was on holiday, 3 more attempts were successfully made. So during this time, Patricia made 3 separate payments, which totaled £193,250. So she was completely scammed by 3 phishing attempts, 3 phishing emails from fraudsters. They claimed to be the managing director of the company. They were obviously using that person's email address. I don't know in this particular case whether it was exact email modification fraud or whether it was 1 or 2 letters different, but either way, they claimed to be the managing director. She acted on that 3 times. And at the end of the day, the company claimed that although the emails were sent from somebody claiming to be the managing director, they weren't sent from Yvonne Bremner's email account, and that was something Patricia Riley should have been aware of. Now, without seeing the detail of what that email looked like, I would argue that the onus is on every single employee in that company, rather than passing the buck, to be fully aware of what email modification fraud is, to be fully vigilant around incoming emails and requests from people. And it goes back to what I said before about checking internally. If you've received an email from somebody, they're asking you to transfer funds or they're asking you to give sensitive information, then do check they've actually sent it to you. A lot of the time, the email address will be identical, so you won't be able to tell it's not from them. That's email modification fraud, full email spoofing. Some of the time you may look carefully and see there's a slight difference in that email, and that would definitely raise an alarm bell. You should never act on anything that you see like that. And although fraudsters aren't using that method very often, because people are catching it much more easily, they're using full email modification fraud and copying the exact address, we are still seeing some of those cases. The SRA scam alerts of just a few weeks back had one about Shoesmiths. There was nothing that Shoesmiths could have done about this. This was client education, but one of their clients received an email from who they thought was their solicitor at Shoesmiths. In fact, it wasn't, and it wasn't the exact email address. They actually have, the firm actually has DMARC in place, which prevents this. So that couldn't have happened for them. But in this particular case, Shoesmiths had an E added to the end of it, and the person purchasing or buying the property just didn't spot that. So again, we have to go back to a combination of using the technology that's available to you, the searches that are available to you, which will prevent a huge amount of this fraud, but also your own internal training, your own internal staff training and understanding about what's going on and what to look for. And you must educate your clients, and education are the key words that we need to be thinking about here. So where does that leave us? Well, it leaves us with a pretty grim picture, but I think we already know that this has been a huge problem and it's only continuing to get worse. At the end of last year, I sat in on a cybercrime update from West Midlands Police. who look at cybercrime stats across the country. And at that stage, and this was coming up on a year ago now, they had estimated that there were 1,400 criminal gangs actively targeting law firms and their funds at any one stage. This is serious organised crime. It's not a group of teenagers sat in their bedrooms hoping to get lucky. They are watching all the time, and they will pick on firms whose procedures just don't cut the mustard. So you need to be doing everything that you can to be protecting yourselves, and there are a huge number of things you can do, making sure that your people, processes and technology are working together. I'm not suggesting there's a silver bullet. There isn't. If there was, we'd all be using it. But in terms of a layered approach to security and a layered approach to risk, you can put a number of these different things together, and combined, you will be covering an awful lot of ground in this fight. As I've said, some of the regulators are heavily scrutinising what you're doing as well. So we now have CQS and Lexel requirements that are pretty much stating these things need to be in there. There is a requirement to demonstrate that you adequately have procedures in place to protect funds transfers, both to conveyancers and consumers. The SRA are extremely interested. The National Cyber Security Centre, which was set up 2 years ago by the government, are also now requiring or strongly recommending that firms have a layered approach, and that in the top tier of that approach, they're implementing an anti-spoofing tool. Now, I will mention that in just a second. It's called DMARC. But to summarise, in all of those case studies, you would have seen that had the client or had the law firm been using either consumer bank account checker or the lawyer checker search, as it's known, to check the conveyancer, some of those frauds could have been avoided. Had they been using account and entity screen, I beg your pardon, had they been using account and entity screen for the conveyancer, that would have been avoided. Consumer bank account checker, which checks the transfer to the consumer, which checks Experian for their bank account number and sort code, would most certainly have prevented a lot of the ones where we looked at the infiltration being on the client side, not on the conveyancing side. And then the DMARC protocol, which I won't say too much about here, but if you want further information, you can certainly get in touch with us at Lawyer Checker, and you can get in touch with Searches UK, who will also direct you our way. But DMARC is a protocol which is recommended by the National Cyber Security Centre as a layer 1 approach in anti-spoofing, and it's the only protocol that exists that will protect your firm from exact email modification fraud. So it means that once that's in place, nobody can use your exact email address with no letters different or no numbers different, but the exact email address to set up an email that will go either externally or internally. That's something you need to be thinking about. On DMARC is a tool that we have that gets that in place very easily and allows you to then work with that going forward. The other thing you need to be thinking about, again, both Lexel and CQS requirements now, cyber essentials, part of the cyber certifications journey. If we look at this journey on the screen here, as a small firm, perhaps with 1 branch or maybe 2, Cyber Essentials would be perfectly adequate for you. It's an annual certification. We are certified assessors, so we would be able to conduct that for you and issue you with your certificate if you'd passed. But it's a basic level in which the government wants people to demonstrate that you have certain levels of security in place and that they are robust enough to demonstrate to your clients that you are at least taking some things seriously around protection and security. So Cyber Essentials is very basic. It looks at things like virus protection, password protection, logins, updates on your systems. It makes sure that you're compliant with your software, that that's still supported. And there's a number of different very basic areas that it looks at, but really good to have that badge in place. And as I've said, that's now a government-backed scheme and pretty much required. It's certainly part of the Lexel and CQS requirements to say that those requirements should be demonstrated through Cyber Essentials. Cyber Essentials Plus is a bit more robust. It requires an on-site survey, probably for the bigger firms out there with multiple branches. And you can also look at things like IASME Consortium Gold, which will cover your Cyber Essentials, but also add on the GDPR elements for you as well. So there is a cyber journey there that you can potentially begin at or go in at any level. That's something you should certainly be looking at as a firm. And we are seeing in the marketplace that there are many consumers now that are actively seeking to instruct firms that have Cyber Essential certification. And if they don't want to do business with them. And I've had that I've been spoken to about that by other managing partners who've said that that's what they're noticing. So really recommend that you get yourselves through the Cyber Essentials. It's really quick to do, and that's something that you can actively do as well to help you in this fight against crime. So I hope that that has been useful for you all. We're just coming up to the hour. I want to leave you with just a little bit of information around this webinar and what's going to happen next. So Samantha Manning at Searchers UK, who has kindly agreed for me to host this in conjunction with them, will be sending out a recording of the webinar to you for all those that have registered, so you can pass that on to colleagues. My contact information is in there. If you would like to get in touch with Lawyer Checker about any of the things you've heard about today, do. Don't forget that you can order your account and entity screen search, and your consumer bank account checker search now is also available through Searchers UK if you're using them as your search provider, and any of the other products that we discussed and services we discussed. So the on-DMARC anti-spoofing protocol, which is important in your Cyber Essentials journey, are things that we would be very happy to talk to you about as a business. We will also be following up with those of you who I think marked on the survey on the webinar that you would be happy for us to contact you from Lawyer Checker, and we'd be happy to provide you with a free cyber report which will tell you where your firm sits in the areas that I've discussed, if that's of help to you. But otherwise, I hope everyone enjoyed the webinar and got some takeaways from it, and I hope that you all enjoy very much the rest of your day, and thank you for listening.